My apologies. Your right hand. Welcome everyone to our Thurgood Marshal event. I would like to introduce the Honorable Judge Susan Craighead.
Thank you all. Please be seated. Good afternoon. I'm Susan Craighead, and I'm presiding judge of the King County Superior Court. And on behalf of the court, I want to welcome you today for this terrific Thurgood Marshal celebration. I know we have a variety of dignitaries with us, and I might miss a few, but I want to particularly call out that we have Council Member Kathy Lambert, Council Member Larry Gossett, Council Member Rod Dombowski. We have Judge Johanna Bender, I see, and I see Fred Jarrett, Deputy County Executive, and I see Sheriff John Urquhart, and Dan Satterberg from the prosecuting attorney. On this occasion, celebrating Justice Thurgood Marshal, I want to talk about an issue that would have been very important to him if he were alive today. I'm very grateful to the organizers of this event for allowing me to deviate from the program today. Now, as you may have heard, on Monday, the King County Council voted to approve a contract with a design-build team to construct the new Children and Family Justice Center. A number of opponents of the building appeared at the hearing to testify and did so very passionately. I tell you this by way of context, although it must be clear that this statement is about something that is far more important than a building. On behalf of the court today, I come to you with a bold statement, the likes of which you do not often hear from government. We are sorry we have not been listening well enough to our community. Some people are shouting at us because they do not feel they are being heard. Many other people in our community may not be shouting, but they may perceive the county as tone deaf. We must sit down with these people and listen. And we need to speak frankly about the institutional racism and racial disparity that persist in our juvenile justice system. In 2014, in King County, for the first time, the number of referrals for African American youth exceeded the number of referrals to white youth. More than half the cases in King County Juvenile Court were filed against African American youth, even though they make up just under 10% of the population. On any given day in 2014, 51% of the youth held in detention were African American. As a county, we have done much great work to reduce the number of juvenile court filings and the number of youths in detention by 72% over 12 years. But these efforts have disproportionately benefited white youth. Youth of color remain ensnared in our juvenile justice system. This situation is utterly untenable. The number of youth in the juvenile justice system is going down, but the percentage of African American youth is going up. This despite the work of many good people of goodwill in county government. Racial disproportionality and the vestiges of racism have no place in our justice system, and we will continue to do everything in our power to eliminate them. As leaders of our justice system, we must take responsibility for our role in allowing racial disproportionality to be a fact of life in the juvenile justice system. We deeply regret this, and today we ask the community's help to make things right. At the same time, we have been hearing many voices who are concerned not only about racial disparity in our juvenile justice system, but who also believe it is wrong to incarcerate juveniles at all. These voices have turned the replacement juvenile court building into a symbol for all that is wrong with the juvenile justice system. While it has not always been easy hearing from these voices, they challenge us to do better. No judge wants to place a young person in detention. We know that detention can increase recidivism and the chances of failure in school. This is why we try to reserve detention for those who are accused of serious offenses and for whom there are no realistic alternatives. And too often, judges find they have no realistic alternatives. We have been challenged to envision a world where there is no need to incarcerate youth at all. As much as we wish we could, we cannot implode juvenile detention tomorrow with no alternatives in place, especially for youth who cannot be released to their parents or guardians. Mothers, fathers, faith leaders, educators, and community workers need to suggest to us community-based and other alternatives to detention that can work and will be accepted by the people of King County. The racial disparity problem we call out today is faced by urban centers across the country. No one so far has been able to eliminate disproportionality. We have the opportunity to set an example for other communities in this nation as we try together to find answers. Today, we announce we are immediately embarking on a series of listening sessions with the families we serve, with the leaders of our community, and with a broad swath of community organizations throughout the county. We will bring together their ideas and combine them with what the data show about the youth who wind up in our juvenile justice system, and in particular, the detention center. We have done more than just about any other urban center to reduce the use of detention. Now we need to know more about the youth who remain there, where they came from, and what their stories are. Already, our community has told us that, too often, youth of color are suspended or expelled from school and wind up in detention charged with crimes, well on their way to prison as adults. Some local school districts are starting to explore using the restorative justice model in lieu of exclusionary discipline. In juvenile court, we are starting a pilot project this month to use the restorative justice model as an alternative to prosecution. We also know that our financially strapped child welfare system may not be able to help families heal from the problems that led to a call to Child Protective Services. What resources can our community provide to help? We have heard young men of color report unwarranted police attention, walking or driving while black or brown. We in the justice system cannot stand by as the community's perception of justice declines. Neither should we discourage law enforcement from protecting and serving African American or Latino neighborhoods. How can we help achieve the balance? These listening sessions will start as soon as next week. As we gather community input and study the stories of youth in detention, we will learn what other professional community partners need to be invited to the table. All of us in county government share this concern about disproportionality. We share with the community the desire to reduce the number of youth in detention. Prevention will take the partnership of everyone with a role in the system, and that includes school districts, child welfare, and law enforcement. We need to hear what the community thinks might work so we can all align our efforts on behalf of helping young people succeed and flourish outside of the juvenile system. For me and my colleagues, we hope that by genuinely listening and responding to the ideas we hear from the community, we might begin to regain the trust and confidence of our entire community. This is not easy. Juvenile court by itself cannot eliminate disproportionality. We need many community partners to address all of the factors that lead youth of color to our doors. We cannot succeed in this effort without the community helping us to develop alternatives to detention. The community as a whole must tackle this problem alongside us, and it will take all of us working together to solve it. Thank you so much for hearing me out on this very important topic. And now I'd like to invite Judge Thorpe.
Thank you, Judge Craighead. Welcome, everyone. We are now stepping back into perhaps our program for the afternoon. I thank you all for joining us. Today happens to be Abraham Lincoln's birthday. That is not a coincidence when we scheduled this event. Very few things that I suppose I plan nowadays are coincidences. But as we start our tribute to Justice Marshall and all that he stood for, I want to read a quote to you from Smith v. Allwright, a Supreme Court case from 1944 that then head of the NAACP Legal Defense Fund, Thurgood Marshall, argued on behalf of the citizens of Texas. The Supreme Court found that the United States is a constitutional democracy. Its organic law grants to all citizens a right to participate in the choice of elected officials without restriction by any state because of race. What do we know about 1944? It was 21 years later before the Voting Rights Act was passed, which was 50 years ago this year. And when we think of the long, dedicated career that Justice Marshall had, fighting for civil liberties, fighting for the right to vote, this organic law that is a fundamental tenet of our Constitution and our country, we find ourselves here. So to start our program, I'm going to invite Michaela Stewart up to sing an abbreviated version of Lift Every Voice due to time constraints. For those of you who are so inclined and so moved, please join with her.
Oh, yeah. Lift every voice and sing till earth and heaven ring, ring with the harmonies of liberty. Let our rejoicing rise high as the listening skies. Let it resound loud as the
that the dark past has taught us. Sing a song full of the hope that the present has brought us. Facing the rising sun of our new day begun. Let us march on till victory is won.
Thank you so much for getting us into that lively spirit this afternoon. It is my true honor and pleasure to introduce to you Professor Lisa Mannheim, who earned her Bachelor's in Arts in English from Yale University in 2002 and went on to receive her JD from Yale Law School in 2005. After law school, Professor Mannheim clerked for Judge Pierre N. Level of the United States Court of Appeals for the Second Circuit, as well as Justice Anthony M. Kennedy of the United States Supreme Court. Professor Mannheim teaches and writes in the areas of election law, constitutional law, federal courts, and civil procedure. Please join me in welcoming Professor Mannheim.
Hello, thank you. Can you hear me all right in the back? It's okay? Is this better? Great. Okay, thank you. That is a tough act to follow, by the way, so thank you for the lovely song. I was hoping to start by saying thank you first to Judge Thorpe and to others here at the court for organizing this event, and thank you also to all of you for coming together today. We are here to honor Justice Marshall through the lens of the Voting Rights Act. This is a particularly fitting theme at a particularly fitting time, for reasons I will explain. Thurgood Marshall was a staunch supporter of the Voting Rights Act. He witnessed its signing through a front row seat at the Capitol, and this support was appropriate. The Voting Rights Act has been referred to as the most successful piece of civil rights legislation ever enacted. It was this radical piece of legislation that somehow, remarkably, made its way through Congress in 1965, which was the same year that police in Alabama attacked hundreds of activists as they tried to march from Selma to Montgomery. And the same radical piece of legislation got reenacted by Congress on 5 separate occasions. Most recently, this included a reenactment in 2006, when Republicans controlled the Senate and the House, and George W. Bush was president. In that political environment, the Voting Rights Act was reenacted with an overwhelming majority in both houses, and President Bush signed it into law in ceremonial fashion. Here's President Bush at the signing ceremony. So I say this just to make clear that even at this late date, in 2006, it was simply unthinkable that the Voting Rights Act would lack the support of the federal government. This act represented a triumph for freedom as huge as any victory that has ever been won on any battlefield, in the words of Lyndon B. Johnson. And even in 2006, the federal government was squarely behind it. And this included, by that same time, the Voting Rights Act already having survived multiple constitutional challenges in front of the United States Supreme Court. In 2013, however, what has been referred to as the steel spine of this law was effectively invalidated. And that steel spine is Section 5, which is what I'd like to focus on. So Section 5 is what made this legislation, the Voting Rights Act, so uniquely effective. And Section 5's recent invalidation is one critically important thing, in my mind, to think about if we are going to honor the legacy of what Justice Marshall managed to accomplish. To that end, I was hoping to start with 2 stories. The first is in the South in the 1960s. So this is a photo of a march in 1963 in memory of 4 girls who had been killed in a racially motivated bombing in a church in Birmingham. By 1965, African Americans on paper had been guaranteed the right to vote for a century. But Southern states had made sure that they never had this right in practice. officials in a state like Louisiana would impose ridiculous requirements, perhaps characterized, to take one example, as literacy tests, and administer them in a discriminatory fashion to ensure that no African Americans could pass. So here's an example of a literacy test that was administered in Louisiana in 1963, and I'm just going to highlight one question that was asked on it. So what this says is, spell backwards forwards. So I would invite you just to take a moment to think about how you might answer this. Perhaps you would, for example, write the word backwards. But let me ask you, did you include the comma? Because if you didn't, you failed because you should have included the comma. Or alternatively, maybe you did include the comma. In that case, you've also failed because you shouldn't have included the comma. So it goes. Now, I have to tell you, I don't really know what this prompt has to do with literacy, but what I do know is that it was deliberately written to make sure that any possible answer could be marked as incorrect. And as the instructions to this test remind you, I'm not sure that anyone's gonna be able to read it, but it's up here at the top. Be careful, as one wrong answer denotes failure of the test. So look, practices like these, they were clearly unconstitutional. So you might think to yourself, why not just challenge these practices in court? And the answer to that question is critical to this story. Because when litigants in the South would bring lawsuits challenging these sorts of practices, state officials would do whatever they could to moot the lawsuits. And what this meant was that it wasn't enough just to win a lawsuit challenging these voting restrictions. As soon as a court declared one practice to be illegal, officials would just switch to another equally illegal practice. So if you take, for example, this literacy test, if a court were to declare it to be unconstitutional, officials would just draft a new one and they'd start administering it the next day. Meanwhile, while all this litigation was ongoing, elections kept happening, and African Americans were still, as a practical matter, completely unable to vote. And what this meant was that this toxic brand of state politics just continued on as usual. So, meanwhile, with this impossible legal situation in the background, people across the country were finding it harder and harder to accept what was happening in the South. Newspapers, TV teams, they were issuing a seemingly endless stream of horrible stories of violence against activists advocating for racial equality. And these devastating images would spread like a nauseating agent across the country. Here are a few photographs from the events in Selma, Alabama, which were depicted actually in the movie that recently has come out. So these are photographs from a central scene from that same movie. And I'll just run through them. So again, this was being publicized across the country. Out of this violence and this publicity, and again, this impossible legal situation, out of that came the Voting Rights Act. President Johnson had asked his staff for the toughest Voting Rights Act that you can devise, and he got it. Because what the Voting Rights Act did was something that hadn't been done before in this country, and which actually hasn't been done since. And what it did was it locked into place the state laws in the South. So Section 5 worked by prohibiting state officials from just replacing one discriminatory practice with another to avoid court review. And now this only applied in certain jurisdictions, mainly southern states, but in these jurisdictions, Section 5 allowed officials to change any voting-related law only if those officials first got clearance from the federal government. And what this meant as a practical matter was that the long oppressed citizens of the South finally were able to challenge discriminatory laws in court. They could prove the laws were discriminatory and illegal and unconstitutional, and they could get them invalidated. And in the meantime, a new, worse law couldn't just be enacted in its place. So Section 5, in a sense, flipped who was in control. It flipped the burden. And this was the novelty or the ingenuity of what this act did. And it was incredibly effective. For the first time, the legislature's hands were tied. Their hands were tied unless they finally just stopped discriminating. And so in large part, they had to just stop discriminating. It finally worked. So that's one story coming out of the South, but I promised you two. And so here is the second. We have to fast forward about 50 years. So this is the United States Supreme Court. So by this time, Section 5 of the Voting Rights Act has had a profound effect on the enfranchisement of African Americans. In the 5 years after the Act's initial passage, to take one example, almost as many blacks registered to vote in 6 southern states as had registered in the entire century before 1965. But now it is several decades later, or more specifically, June 25th, 2013. On this morning, Chief Justice John Roberts reads from the bench in the United States Supreme Court his opinion striking down this same section, Section 5 of the Voting Rights Act. And so as of this morning in June 2013 and continuing to this day, Section 5 no longer has any effect on any jurisdiction in the country. So here are our 9 justices. The Chief Justice is right there in the middle. So in explaining his decision, Chief Justice Roberts used an expression. And the expression he used is, history did not end in 1965. And by that, he meant that all of those terrible things we just talked about, the violence, the disenfranchisement, the blatant disregard of federal law, that all happened in the 1960s, and it's not the 1960s anymore. And so according to the Chief Justice, Congress can't keep just relying on those old facts and that old data in justifying the current burdens of the Voting Rights Act. Instead, the Constitution requires that Congress point to something new to justify the burdens. And according to the Chief, Congress had not done that. So Justice Ginsburg wrote this dissent. She's here on the right. And in dissent, Justice Ginsburg ironically agreed with at least one thing that the Chief Justice said, and that's that history didn't end in 1965. But that's because, in her words, quoting Shakespeare, what's past is prologue. And so what happened in the 1960s has continued to affect the shape of the country today. And while now we may not have literacy tests and other, quote, first generation barriers to voting, what we do have is what Justice Ginsburg refers to as second generation barriers to voting. These would include things like gerrymandered districts, the use of at-large voting, or even something like inconvenient polling times, practices like these. And these second generation barriers were also what the Voting Rights Act had been resisting by simply freezing everything into place. So to take one example, prior to this 2013 Supreme Court decision, in a place like Texas, state officials had been required to prove that a voter ID law didn't discriminate before they could start enforcing that law. And the state hadn't been able to prove it. So it never went into effect. No voter ID law in Texas. But the majority rejected this regime. It rejected Section 5, essentially on the ground that, as a result of Section 5, things had gotten so much better. Now, according to Justice Ginsburg, this rejection makes about as much sense as throwing away your umbrella in a rainstorm because you're not getting wet. Okay, but again, that was the dissent. The majority concluded otherwise. And as a result, Section 5, this unique piece of landmark legislation, no longer has effect in any jurisdiction, any of the jurisdictions it once covered. So what has happened in response? The Supreme Court's decision came down less than 2 years ago, so we're still trying to figure out its many effects. But one thing we do know is that the political response was powerful and it was immediate. So within hours, literally hours of the Supreme Court's decision, then Texas Attorney General Greg Abbott announced that he would begin enforcing the state's strict voter ID law. Previously, Section 5, as I mentioned a moment ago, had blocked the implementation of this voter ID law because of its racial impact. So here's one of a series of tweets that the Texas Attorney General sent out the morning of the Supreme Court's decision. And what this one says is, Eric Holder can no longer deny hashtag voter ID in Texas after today's SCOTUS decision. So in a state like North Carolina, you saw a similar response. The state legislature quickly enacted a law that is widely regarded to be the most restrictive of modern voting legislation. This law imposed a strict voter ID requirement, it cut back on early voting, it narrowed the window for voter registration. In Alabama and Mississippi, you saw a similar pattern, and all of these laws would have clearly required Section 5 preclearance. And in all likelihood, none of them would have gotten it. So the list goes on. Voter purges, new redistricting plans, moving dates of elections. State and local jurisdictions previously covered by Section 5 have begun implementing all these sorts of changes. And again, this is a direct response to the Supreme Court's opinion. So if I might take a moment, I'd like to discuss for just a sec a particularly vivid example that has come out of Texas. I mentioned already the voter ID law that this tweet is about, the voter ID law that Texas began to enforce as soon as the Supreme Court's opinion came down. Now, a year later, a year after this tweet, after challengers had had to fight the law through onerous, resource-intensive litigation, a district court in Texas concluded that this voter ID law, among other things, intentionally discriminates against African American and Hispanic voters. So here's an image from the opinion for the lawyers in the room. So this was just a few months ago. And again, the court found that the voter ID law intentionally discriminates against African American and Hispanics. Particularly in this day and age, this is an extraordinary judicial finding. Yet the elections in Texas in 2014 nevertheless went forward with this law being enforced. Politicians were elected in Texas this November with voters being subject to this discriminatory voter ID law, and the politicians who were elected are now serving their terms, casting their votes, just like every other elected politician. This happened because no longer was a jurisdiction like Texas required to wait and to prove a lack of discrimination before implementing a law like this. So, you might think to yourself, maybe this is all just a matter of timing. Won't the court be able to prevent Texas from implementing this law by the time of the next election? And if that's the case, then what difference does it make? So the answer to the first question is yeah, maybe. Maybe a court will enjoin use of this law by 2016. But this just brings us back to the story of the 1960s. Because in elections, delay, sometimes it can be everything. Legislatures can keep enacting and revising and reenacting laws that accomplish basically the same thing as the laws that have been challenged. And meanwhile, politicians keep getting elected, litigation is always playing catch up, and there is no recourse for the politics that happen in the meantime. So this is the world that we're now in. And I was hoping to conclude by just asking, all right, well, what can we do at this point? Or to put it another way, if this bothers you, what can be done about it? In so many areas, and certainly in the world of election law, law and politics are intertwined. And at least for now, supporters of Section 5, they've lost the big legal battle. That doesn't mean it will always be lost, but it's lost for now. But that still leaves politics. So this is a picture of a voter being registered. One of the most important responses to the challenges facing the Voting Rights Act is to remember what Section 5 did that was so revolutionary. And that's that it found a way of stopping state legislatures from enacting discriminatory laws. But there's another way of stopping them, and that's through politics. These voter ID laws, these gerrymandered districts, these restrictions on voting times, these laws can be resisted before they are enacted. And they can also be repealed through politics. And to take it even a step further, legislation that's affirmatively protective of voting rights, that can also be enacted at the state level, even in the face of federal gridlock. And again, this is through politics. Now, I have to admit that to the extent that these voter ID laws and other related barriers are part of what it makes it so hard to get voting rights protective politicians into office, that's one of the frustrating and perverse consequences of the dismantling of Section 5. But effecting voting rights change through politics nevertheless can be done, and it is a reminder in this circumstance of just how important state and local races and politics are. Across the country, these state and local races are races to care about. Now, of course, this is not the only response to the recent challenges facing the Voting Rights Act. Still, this sort of response, a political response on a state and local level, I think can often be overlooked amid the other very important responses, the commentary, the criticism, the legal challenges, all launched in the wake of a case like this 2013 case. Okay, this all said, perhaps the most important thing to remember is something much more fundamental. And that is to not feel helpless or resigned in the face of these sorts of challenges, but instead to keep advocating for what we feel is right. Here's another photograph of Justice Marshall. He really did have a remarkable life. This is him outside of the Supreme Court after the decision came down in Brown versus Board of Education, a case he litigated. I mentioned before that Justice Marshall had been in a front row seat at the Capitol for the Voting Rights Act. And he was, of course, not coincidentally, right there when the first African American justice was sworn into the United States Supreme Court. In his lifetime, Justice Marshall was witness to enormous progress and astounding success. But these milestones, they took a career, a lifetime of work, and it was hard, and the justice witnessed important things go backward as well as forward. So as we honor Thurgood Marshall by exploring the rise and admittedly the recent tumble of the Voting Rights Act, it is vital that we look not only to how progress has been met recently with challenges, but also that we look forward to just how much can be accomplished in a generation or a lifetime by those committed to equality and justice.
Thank you so much, Professor. Ladies and gentlemen, it is also my privilege and honor to introduce to you LaRon Baker, Staff Counsel for the ACLU of Washington. Ms. Baker graduated from the University of Washington School of Law, go Dogs. Ms. Baker has been counsel in lawsuits challenging the denial of religious accommodations to Muslim inmates in the Pierce County Jail, to the placement of immigrant detainee hunger strikers in solitary confinement, DSHS's failure to provide timely court-ordered mental health services to those who are incarcerated, and City of Yakima's at-large election system under Section 2 of the Voting Rights Act, depriving Latino voters and Latina voters of their right to vote. Ms. Baker.
Good afternoon, everyone. It is quite an honor to be here today, celebrating, let me put that over here, Thurgood Marshall and the anniversary of the Voting Rights Act, and to be here with so many wonderful speakers. Thank you all, and thank you for the comments that were made today about the juvenile justice facility and the concerns that are arising in our community about issues with racial disparities in the juvenile justice system. I'm heartened to hear that here at this celebration, especially as we celebrate the Voting Rights Act. So we are here to talk about the amazing improvements to American society that Justice Marshall and all of those who could not and would not sit still and be silent in the face of injustice, and all that was achieved through their tough-minded dedication to advocating for equality and compassionate concern about those who are most disenfranchised in our community and society. And so we are here 50 years out from the passage of the Voting Rights Act in a world that is dramatically improved but still subjects many to the same injustices that were so strenuously challenged 50 years ago. So I want to give just a little bit of a background about the ACLU, the American Civil Liberties Union. There are some who probably most certainly know who we are and what we do, but I want to make sure that all in the room do. The ACLU is an organization that advocates for the civil liberties and civil rights of all people. Our priorities include racial justice, free speech, freedom of religion, and ensuring that all individuals and communities are treated fairly, equitably, and are protected from undue government interference in their lives. The ACLU has also long advocated for meaningful access to the vote, both here locally and nationally. The guiding principles of our voting rights work are, one, that all Americans should be able to vote, two, that voting should be free and easy, and that all votes should count equally. And this indeed was the promise of the Voting Rights Act of 1965, a guarantee that so many have fought for decades, and as we have heard, is struggling to remain, I guess, as relevant and as important as it has been historically. So Professor Mannheim spent a great deal of time talking about the history of the passage of the Voting Rights Act, what people were up against, what voting practices were in play in 1965. And it's important for us to remember that at that time, the civil rights movement came after African Americans had fought for decades for freedom, first from slavery, and then against violence and governmental restrictions, and it reinforced segregation and the subjugation of people of color. It is also important to remember that in 1965 was around the apex of communities of colors and their allies demanding that American institutions provide them equal protection under the law. And the individuals who took to the streets, the courtrooms, the schools, the churches, and the lunch counters who demanded equality knew that having access to the vote was integral for any meaningful and lasting change to occur. This is because voting is the cornerstone of democracy and is the fundamental right upon which all of our civil liberties rest. What I mean by that is being able to have meaningful access to the vote is what allows individuals and communities to ensure that their voices are heard and that by those making decisions on those behalf, and that their ideas, concerns, and needs are considered and represented on those same decision-making bodies, and by those who make decisions about their lives and impact them. This is the purpose and the goal of the Voting Rights Act. It is to ensure that those communities and individuals who were disenfranchised in the past based on particular characteristics are assured the opportunity to have a say in the political process. The VRA, the Voting Rights Act, has multiple enforcement mechanisms. Professor Mannheim talked about Section 5, which is the one that is most known to most people. It's the most popular. It's the one that had a lot of traction, although it is not the only enforcement mechanism. I will talk to you about the other two, actually. The other two methods, first, one of them is known as Section 2. And what that is a part of the Voting Rights Act that prohibits election systems from that allows individuals and communities to challenge election systems that disproportionately impact or limit the voting power of individuals or communities of color. So what that means is under Section 2, a group can come in and challenge either a new system that's in place, say a voting ID law, or a districting system, or any other requirement that disproportionately impacts a community of color. And they have no need to make a showing of intentional discrimination. Unlike Section 5, which only applied to certain parts of the country who met a particular matrix regarding their past voting practices, Section 2 is available for communities all across the country to be able to, as a means for them to ensure that they have meaningful access to the vote. And I will talk to you about at least one Section 2 case that is live here in Washington State in a few minutes. But that is one of the other enforcement tools outside of Section 5 that's available under the Voting Rights Act. Another is Section 203, which this section seeks to protect access to the vote for individuals and communities that are language minorities, so communities of people who do not speak English as their primary language. And what this is meant to do is ensure that the polls are meaningfully open to individuals regardless of whether or not they speak the majoritarian language. And so it requires jurisdictions to provide voting materials in other languages if their population meets a certain percentage of speaking another language. So in Seattle, say, if 5% of that city were known to speak Amharic, the city would be required to provide election materials in that language. And this is across the country, and it relies on census data, and it ensures that as demographics change and as different communities move into a place, that they are not kept out of the process of being part of choosing who represents their interests in the governing bodies around them. So generally speaking, so those are two systems outside of Section 5 that are part of the Voting Rights Act. But generally speaking, when we think of the Voting Rights Act and voter disenfranchisement here in the Northwest, especially we think of the South. It's really easy for us to think about that here, in part because the South played such a huge role in ensuring that African Americans and other communities of color had access to the vote. But what is a disadvantage is that oftentimes people stop thinking about limitations on access to the vote in any geographic area outside of the South. And the limitations on the vote for people of color has occurred all across this country and has manifested itself in multiple different ways, whether that's from literacy tests that were administered in other states or outside of the South or other sorts of practices. Here in the Northwest, there are a few different Section 2 cases that have been brought, and one of them is called Montez versus the City of Yakima. I'm not sure how many of you have heard about it, but yeah, at least one person. So that case was brought by the ACLU of Washington, and was attorneys from the law firm Perkins Coie, Kevin Hamilton, Abakana, and William Stafford were on the case with us, and they did excellent work, amazing work, and the background of which I will tell you about right now. But the case was brought, I don't know how many of you have been to Yakima, but Yakima has a growing and significant Latino population. And in the city of Yakima, currently about 40% of the community are Latinos. But on the city council, a Latino has never been elected to the city council. And in all of the other governing bodies in that jurisdiction, Latinos have not been able to gain seats through the electoral process. And so the ACLU, when looking at these trends across the state, along with other concerned communities, decided that it was time to really ensure that communities of color in Washington did have meaningful access to the vote. And so when we looked at the system that was in play in Yakima, it turned out that the Yakima election system was an at-large system. And so what that means is that everyone in the jurisdiction voted on every seat on the city council. And those of you who live in Seattle are probably familiar with this because we are changing our system too. But everyone in the city of Yakima voted on every single seat in that city council. And what that resulted in was an inability for Latinos to elect people to their seat because of racially polarized voting in that jurisdiction. What racially polarized voting means in this instance is that the white majority in Yakima votes very differently than the Latino majority in Yakima. And so when there were seats that would come up for election, the majority population was always able to elect someone to represent their interest to that particular seat. And so what we advocated for was for 7 single-member districts. This would allow the growing Latino population to have someone on the city council, on an electoral body who handles budgets and other decisions that affect them on a daily basis to be able to represent their interests. They'd be able to get someone who could say, you know, in the part of town where the most Latinos live, we need X, we need more parks, we need our infrastructure to be kept up better, we need someone who can advocate for a fairer distribution of resources. And that lawsuit was brought under Section 2. So that was the section of the Voting Rights Act that doesn't require a showing of intentional discrimination. It requires a showing of many other things in a vote dilution claim, including a statistical analysis of past elections. And a showing of a number of historical factors, including a showing of discrimination that has occurred in that jurisdiction. But when we looked at the elections and started looking at the evidence as it came in, one of the things that was most compelling about that showed the difficulties of Latinos actually being able to elect someone to this body, this electoral body, were two elections that are pretty compelling. One of them is Justice Steve Gonzalez, who I'm sure some of you know. When he ran for the state Supreme Court, he actually won the election, thankfully, but he lost in a number of key jurisdictions, and one of those was Yakima. And when you looked at the election data, the majority of Latinos voted in support of Justice Gonzalez, and the majority of people who were white voted in support of his opponent, Danielson, who I believe was underqualified, and he had not run any affirmative campaign, and he had actually been anti-endorsed by his own bar association in the county that he lived in, whereas Justice Gonzalez had the support of almost all of those who came out and gave endorsements. But his opponent won the city of Yakima anyway. Another key example that shows how difficult it was for Latinos to elect representatives of their choice to these representative bodies was a school board election with a woman by the name of Graciela Villanueva, who had been appointed to the school board, but she went up for election and lost her seat to a woman who had actually backed out of the election months before. So she had resigned her place on the ballot, said she wasn't going to be up for election. There was a large community conversation about it. It was in the newspapers. Graciela Villanueva was supported by all of the school board members. But when it went out for election, the majority population voted for the woman who had stepped out of the race, but done so in a time where her name was still on the ballot, and Graciela Villanueva lost her seat. Ultimately, the woman who won the election took the seat and months later stepped down, and Graciela Villanueva was reappointed to that position. And so those elections really show in Washington State how important it is that the Voting Rights Act continue to be utilized and shows its relevance here. So where that case is we actually won on summary judgment. And right now we are waiting for the judge from the Eastern District of Washington, Judge Rice, to issue a final remedial order about the plan that will be implemented with the new election system. And so the Latino community there will finally be able to have a legitimate chance to elect a representative of their choice to the council. And in researching that case, it was really interesting because a number of other voting rights acts came forward during that research, one of which was a Voting Rights Act challenging literacy tests here in Washington State in 1968-69. It turned out that in Washington, who knew, there were literacy tests that were administered to individuals here. And the ACLU successfully challenged that. That in 1968 to 72 is when it finally came through. There also have been challenges under Section 203 for jurisdictions who failed to provide meaningful access to electoral materials in the language of growing populations in their community. Another case that is of relevance here in Washington State when we think about voting rights is a case that has a dubious history in the courts, but ended up spurring a significant amount of change. That was called Farrakhan v. Gregoire, and that was a challenge to the felon disenfranchisement law. So the law that said if you were a felon, you lost your right to vote. And there was a challenge that was brought saying that disproportionately impacted people of color, African Americans, and others throughout the state. There was a significant briefing both at the lower court, trial court level, and then up to the Ninth Circuit and back a few different times around this issue. But one of the things that came out of it was a real discussion about the impact of restrictions on voting to felons when we have a criminal justice system that disproportionately targets communities of color, and what that means not only just in the criminal justice system, but what that means in the larger electoral practices. That case ended up being resolved separately in the Ninth Circuit, but it did spur a discussion here in the state and helped to be a catalyst to the change of law here that allows for felons to vote after they are released from incarceration. And so I talk about all of this because while we think about the South as being the key area where voting rights have been at issue, where we think about it, where we are in this moment of feeling pretty at a loss of what to do with the loss of Section 5 and the protections that offers, the remaining parts of the Voting Rights Act are still there and are still able to provide protections to individuals and communities of color. It most certainly is an uphill battle, and we hope that Section 5 is revived. But I wanted to draw attention to what has happened here locally and what can continue to happen even as politicians work on reviving Section 5. There also is a proposed bill, the Washington State Voting Rights Act, that is alive right now, and that's an attempt to create a state law that is separate from the federal law that protects the voting rights of individuals and communities of color here in Washington State. And if you want to talk more about that afterwards, I definitely will be here and can answer questions. But all of that said, it's a rough year to celebrate the Voting Rights Act And it's a rough year to celebrate all of the work that Justice Marshall has done, but that does not mean that we can stop, and it does not mean that we should give up at all. And there are many tools and many opportunities for us to continue doing the good work that he has done and to continue advocating for the populations who have historically been disenfranchised in our country. Thank you.
Ladies and gentlemen, I realize it's a little after 5, but we were very close. If I could get another round of applause for our wonderful speakers who will be staying a little bit later. And a round of applause for our American Sign Language interpreter, Linda Burgess-Duncan. Hopefully she will hear us in the hallway. I cannot thank you all enough for attending and supporting this program. I want to thank all of my colleagues for coming out in force of this great and memorable year. While it has been a hard time and a hard path, as we stand here, let's not forget that it took 21 years from Smith v. Allwright to the Voting Rights Act, 50 years for us to get here today. And there are many years ahead of us. So I challenge you all as you leave here today, carrying these good feelings of progress and hope, that you fulfill Justice Marshall's dream and goal. Exercise your organic law and your organic right to vote. Thank you.